them send someone with more experience.
Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault.
Procedural matters, and
And you're
unfortunately, you have
charged
not.
with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
The wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
That correct.
Dati mihi Anglican por servus Latina. I didn't ask you to interrupt.
That's literally not true.
Oh, for Trump's sake.
You don't put a diplomatic plate on a hoopty.
Yeah, do not put a diplomatic plate on a hoopty, whatever you do. But do come back and hang out with us this afternoon as we continue watching the South Carolina versus Chow case. Good afternoon. Welcome to the Court of Public Opinion. I am the Recovery Addict.
Remember in the beginning when we started 110 years ago?
Why is there an echo? Hello. All right, welcome. First day to listen to this trial catch-up this weekend. Rita, this is a tough one. I have vacillated. I guess some people would call it flip-flopped on this. And I don't know how it's going to end up. I really don't. But it could end very soon. Even though I anticipate this might be a lengthy deliberation. So usually when I think it's going to be quick, it goes a long time. When it's supposed to be long, it goes short. So we'll see what happens. But defense has had one witness up so far. And why is that blurry?
I'm going to sustain my own objection.
I have to turn it off and back on again. Hold, please. Okay. Turn it off and back on, and now it's still a little blurry.
If you could just use your words.
More blurry. A little bit better. I don't want you to be able to read the text on my phone, but we see everything clearly would be good enough. Red Pen, thanks for having you back this afternoon. Appreciate it. Look at this. Tony Zamora. Tony, my friend. Attorney level support for 16 months. Tony, I think you are an OG. OG? Helping out the channel in a big way. I appreciate the updates and information we get. Speaking of updates and information, though, July 1st, which is coming rapidly. It's going to be May. It's almost over with May. May is almost over, in case you hadn't been tracking the calendar. And mine won't pull up, so I can't show you, but just one second. Let's see. July 1st, or June 1st, excuse me, is Monday. On Monday, we have a hearing back in Utah with Tyler Robinson. So we're going to be carrying that live on the Top Rank Media channel, and possibly, depends on what we're doing here, possibly carry it live on the channel. Maybe while we're doing Verdict Watch. Depends on how things shape up today and tomorrow. But either way, you'll be able to find it at least over on Top Mark Media. That's an oral arguments hearing in the Tyler Robinson trial. Get more of Miss Nestor. What more could you want? Cody Height, member for 11 months. Next month I got a new caller. Does anybody know the makeup of the jury in this case? No, but we might get a court watcher. Maybe. We're keeping our fingers crossed. Evangeline Light gifted a goat trophy. I love this one. It almost deserves a goat yell every time. Greatest of all time. Thank you very much, Evangeline Light. You are the goat. Let's see. Supermom says, I'm in Indianapolis and my house was shot up 11 times and we knew who done it. And the detective said because he said they did nothing, so cops sometimes don't always help. And I don't know the background on this particular case in South Carolina enough to say that was the situation here. I don't know if the store owners were just fed up with, we call the cops, they show up 6 hours later, we give them the pictures, They either don't prosecute or they give them a deal, and next, we see the same person back in our store a week later. I don't know if that was happening and they were just tired of it, or if they were just doing what they thought was best. And, the cops have been very supportive. I don't know. Buffer, I can't read chat very well when on screen at the moment. Sorry, Josh. I'll take it down. Our servers are... Oh, never mind. That's your buffer sound. There are times that I have to replay things. It's like, what did they just say? Yes, very often. Oh, look at this. Holy smokes. Sherry Ward just gifted a... hang on, make it work. Come on, there it is. A goat trophy as well. Sorry, I have to... And Fetsnaz gifted sunshine. Fets, thank you very much. Appreciate it. Fets knows, I think. Let's see. Conversely, we reported a bike stolen from a garage months later, says Ripen. Months later, the police called and said they had it. Always make your police report. It can pay off. Can. I'm a big fan. Okay. I've told you where I stand on this case right now. What is? Oh. Hang on, I've got to call really quickly. Okay, hang on. I've rebooted my phone. I'm going to see if this works. Hold on.
Are you there?
Hey, the Brown Barn, are you there?
Hey, I'm here.
I can hear you now. How are you doing?
I'm well. How are you?
Fabulous.
Awesome. I don't know how long we have before they come back. But I wanted to mention something to you that this trial is really making me think a lot about another situation in South Carolina out of Horry County. I don't know if you're familiar with the Weldon Boyd, Scott Spivey situation in Horry County. Have you heard anything about that?
What state are we in again?
In South Carolina.
In South Carolina.
Horry County, South Carolina.
I haven't heard a lot about it.
Okay, it's similar to this one, and it's making me think a lot about it, because it's like, at what point does the person being pursued get to defend themselves?
Right.
And that happened in this case in Horry County, South Carolina, where allegedly there was like a road rage incident, and two men in pickup trucks chased another man in a pickup truck for about 10 miles.
Wow, that's dedication.
And at some point, and they exceeded like 100 miles an hour. Like the guy being pursued was obviously trying to get away.
Yeah.
He did brandish his weapon. The guy
As one does.
did show a weapon.
As one does when you're being pursued for 10 miles at 100 miles an hour.
Yeah. So at some point, he turned off the main road in the direction of his house, and the two men pursuing him continued to follow, and then he pulled over, the single guy, the Scott Spivey, pulled over and allegedly got out of his car with his weapon and said, stop following me, or why are you following me, or something like that. And the whole time, the Weldon Boyd guy is on the phone with 911, so this is all recorded.
Yeah.
But they say, they're saying if he keeps it up, we're going to have to, we're going to put him down. We're going to take him down if he keeps this up, as they're pursuing him. And then when he pulls over, they say he raises his gun, and I don't think there's any eyewitness that particular thing happened. They did say that he had the gun, but they shot and killed him. And
wow.
There's no criminal charges in that case, which is interesting. The Weldon Boyd had the police chief of Horry County's phone number in his phone and called him directly, and so there's a lot of personal connections he has with the police department. Yep. But interestingly, the family did file a civil suit, and there was a stand your ground hearing,
Mm-hmm.
and neither of these men qualified for immunity in that stand your ground hearing.
Yeah. So it goes
In the civil.
So it's
case.
going to court. It's going to trial, is what we're saying, right? But you said no charges filed.
No, there's no criminal charges. This was just in the civil. Yeah, this was just in the suing
civil.
that basically to allow the family to pursue civil litigation against them. But it's so interesting. Like, at what point did this young man that was being chased by these other men
Have the right to defend
have
himself.
the right to defend himself? I don't know how you
Here's a
you tease that
Here's
apart.
a thought exercise for you. Is it possible that everyone in this case followed the law, with the exception of the young man carrying the gun in the store, which is not relevant? I'll admit that right up front. It's not relevant. Is it possible that everyone followed the law, with the exception of him carrying the gun, but we exclude that, and we still end up with somebody dead, with everyone being legally where they're supposed to be? Like, legally protected in their actions.
There.
So Cyrus had the right to defend himself, even though he didn't legally have the right to possess the gun. He had the right to use his gun in self-defense if he hadn't done anything wrong, which, from his vantage point, he sure hadn't done anything wrong to these people, right? He hadn't stolen anything from them.
Yeah.
He was innocent
Right.
in this altercation, even though it might have looked suspicious or whatever.
Yeah.
You don't have to stop when someone tells you to stop. You can run. You can do what you want, unless it's the police.
They were not the police. They were not the police. Yeah.
So I can look at this and say, yes, Cyrus could be in the right to use deadly force if he was in fear for his life. And we, unfortunately, tragically, aren't able to see, what he thought. But I'm guessing he probably wasn't just calm, cool, and collected at the moment, thinking, everything's peachy keen at the time that these two men are chasing him.
Yeah.
But if he's in fear for his life and he uses or brandishes the firearm in self-defense, doesn't even fire it, right? I think you can say that he was within his rights to defend himself because he was in fear for his life. At the same time, the Chows were within their rights to shoot, to defend Andy Chow.
Yeah.
And then we just have this tragic scenario where lack of communication has created this no-win situation where somebody has to die. And it's...
Yeah, I really was in support of the state on these charges until I heard Andy Chow's testimony, and I really think I can get to hearing him say how he was like moving away laterally. Andy Chow was moving away. I wasn't watching; I was driving and listening, but it sounded to me like he was saying he was moving away laterally.
Yeah.
And the young man still had the gun, was still able to point the gun, yet still falling down and moving away. So indeed, he could have been shot in the back at the same time he was threatening Andy Chow.
There's a lot. I would say it's what Andy said is possible. The problem is Andy's the only person saying what Andy said, right? Andy's the only person saying there's a gun. But a lot of other people can't account for where the gun was. They say, I didn't see it.
Yeah.
But there was a gun found. Okay, we know that even the state says the gun was out when he fell the first time. That it fell out. That it could have fallen out of his coat, his hoodie. So, and there is one of the state's witnesses, the guy in the Honda, who described Andy as having his hands up and backing up into the street, which would support Andy's
and that's exactly
saying,
what he said.
I saw a gun. I put my hands up and was backing up. So. Yeah, it's tragic.
That's a good one. Thank you for choosing it.
It's not a good one because there's no winners here, right?
It's good in a very interesting, thought-provoking way.
I'd like there to be a bad guy where we can be like, I'm on the side of right here, right, and this person's wrong. But personally, I don't agree with what the Chows did, even if the law allows them to. I can't tell them no, you can't, because I don't like it. But if they have the right to defend their property, they have the right to. Even though the police said they had the right to pursue him, they have to use common sense, but they have the right to do it.
That's right.
I think there are better ways to handle problems than what was exhibited here, and I think there are probably a million different ways this could have ended, and opportunities to end it differently. than what it did. So
Absolutely.
tragically avoidable,
Yeah.
yes, but also within the rights. Okay, well, it looks like they're starting up again here.
Yeah.
So the Brown Bar, thanks
Okay.
for the call.
Well, look into that. Yeah, when you have time, look into the
Hang on. Say that again. Say that again.
I said, when you have time, look into that Weldon Boyd Scott Spivey issue out of Horry County, South Carolina. Just read up on it. It's interesting and very similar. It reminds me of this one. So.
I think you guys are trying to get me to go down to a South Carolina case. We might have to make a little road trip.
Well, there's no criminal charges in that one, but hey, we got to go to Murdaugh.
Murdaugh's coming. All right, we got to go. All right, thanks, the Brown Barn.
Bye.
We'll see you.
Remind the cell phone must be turned completely off on left, top, or right.
Yes, sir. The last witness who testified, Andy Choi, we put in defense exhibit number 3, which was the body-worn camera that he testified about. If you remember, we took a pause during his testimony of the video. The reason we paused is it was going to get into something about a prior shoplifting. So we paused it. It was not played for the jury. I think we stopped it in time. I went over to I think you saw me go over to a state table and tell them that that's why we were pausing, because I saw that was coming up during the lunch break, where we redacted to take that complete clip out. It has just been muted, Mr. Scott, completely based upon what the jury heard. So it's been muted out. So we'd like to replace, we'll leave it, of course, but I guess supplement this and make this defense 3A. And then before it goes to the jury, we would ask that the state have opportunity to review it and make sure it's what I've said.
Okay. But then 3 would not go to the jury.
3 does not go back to the jury.
Okay.
The defense almost opened the door to prior shoplifting.
Mr. Scott, do you want me to replace 3 with 3? Would that be easier?
That's fine.
Yeah.
I think that'd be the easiest thing. Just we'll note the record that the
Prior spike who?
redacted version is now the only.
Yes, sir. It has redacted. So, Your Honor, and that's Madam Court Reporter, I asked that she mark that as 3, and then before it goes back to the jury, if the state could have opportunity to review it to make sure it is what I have said that it is. Thank you.
Are we ready to see?
This is ready, Your Honor.
I'm Mr. Cole. Get security, please, sir.
So a federal judge had to apologize to her staff after getting caught having relations with an Atlanta police deputy chief in chambers, and everybody heard it. Oh yes, it was loud. Loud is the operative. I left that part out, Red. I didn't think we need to put all the words in. But they're both still doing their thing. I mean, not like that thing, but she's still federal judge and he's still police deputy chief. She gets to keep her robe, even if she wasn't used. Never mind. No. There's lines. We're not going to say that. But she was the judge who sentenced Todd Chrisley to prison. Todd Chrisley was they were TV. Were they the Chrisley Knows Best, the TV series? I think there was tax evasion or something. Anyway, so that's happening. She has not been disrobed. No. She's still at it. How do we know whether or not Cyrus was reaching for the firearm when Chow pulled the trigger? 2 people. Andy testifies that he saw it and was backing away, and the state's witness in the white Honda says he saw Andy with his hands up backing away. Which, why would you put your hands up and back away from somebody unless that situation was as it unfolded? Now, the Honda driver did not see the firearm. He only saw Andy hands up, back away. You'd have to believe Andy and that witness. Yeah, there was a state witness that put Andy with his hands up at the scene, right at the time of the shooting. And it was the one who said he was driving along, keeping pace with them, watching out his window. He was right there. He was the closest witness to that event. But he would have been potentially behind Andy in line with Cyrus. So those three would have been in a line, and he would have seen the dad and Andy. Debbie, it couldn't have been put his hands up and backed away because he was shot in the back. Cyrus was shot in the back.
Thank you, Your Honor. Your Honor, defense call Mr. Richard Carter.
Holly Ann, I heard it that he said Andy had put his hand up and backed away. You heard it as Cyrus?
Thank you. Please have a seat in the witness stand and state your full name for the record.
Interesting.
Thank you, Mr. Carter. You've come a pretty good distance today for us, and I appreciate that. You are actually Investigator Carter, is that correct?
No, sir.
All right.
I'm a deputy with Lancaster County Sheriff's Office.
Deputy Carter. But your work with that department and other departments prior to that have been as an investigator or investigation of crimes?
Yes, sir.
Or potential possible crimes?
Yes, sir.
So, lawyers are supposed to be very good at asking questions. That's not always the case, as I'm sure this jury has experienced. So if there's a point where I ask a question that makes absolutely no sense to you, do not hesitate to say, could you ask me that again? Or can you ask it in a different way? I'm very content with that, okay? Because it's very important that everything that you hear from me by way of a question is understood and that your answers are very clear for their understanding, okay? Mm-hmm. Thank you, sir. And you're going to have to, I'm going to pick on you because before I start, she will grab you by the neck and say, you can't nod your head. You did say, but...
Sorry. Yes, I understand, yeah.
You got to be very careful about that because you know you've testified before.
Yes.
Probably dozens of times, so it's an easy habit to lapse into. So I'll pick on you before she gets on you. Now, you're employed at Lancaster
County Sheriff's Office.
And you drove there today, from there today.
Yes.
You got to work tonight.
Yes.
Well, I want to ask you a little bit about your law enforcement career. So prior to working in Lancaster, you call it Lancaster, I call it Lancaster, and I'm from here, not Lancaster. But where did you work before that? And just tell the jury, if you will, just give them a little quick narrative of the departments you worked in.
I'm on year 30. Prior to Lancaster, I worked for Richland County for 21 years. And prior to that, I worked at Mount Pleasant. I started my career in North Carolina, Carolina Beach PD.
I can't imagine why you left the beach, but okay. You came inland, and prior to all of those 3 stops with those departments, you went to the Criminal Justice Academy?
Yes, sir.
You got trained there. You worked out of state with law enforcement?
And
you worked with the department out of state?
I worked in North Carolina with Carolina Beach Police Department. Okay. That's where I started.
All right, Carolina Beach, I got you. All right, sir. So you were trained at the academy, and at the academy you took courses and were trained on things like crime scene investigation?
Yes, sir.
Witness interviewing?
Yes, sir.
Things that you do when you go to a possible crime scene, the kind of a list of things to do?
Yes, sir.
As an officer on the scene?
Yes, sir.
And just for a moment, I want to dwell there and ask you, the things you do when you arrive at a crime scene, is there a priority or how you approach it, how you were trained to approach a crime scene?
Yes, sir.
All right, can you tell them about that?
As an initial responding officer, first is provide aid to the victim or injured. Then it's to secure the crime scene, preservation of the evidence, and to determine witnesses or individuals that may be present who have information regarding what occurred.
All right. And in terms of identifying witnesses, is it important to talk with the witnesses, interview them, get information from them?
Yes, sir.
And is there a preference in law enforcement and in your training about how soon you interview people to get information from them?
Yes, sir.
And what's that preference?
I mean, when you're initially on the arrival on the scene, if people have information, it's important to identify who they are and what it is that they have seen or have not seen.
Is it important to do that sooner or later if you got the manpower to do it?
Sooner.
Why is that?
Because the individuals that may be there may not be there when you get to them.
Might wander off?
Correct.
Are there other reasons that make it important to interview them? First, do you interview them, you get a group of witnesses together and interview them together, or what do you do?
No, I'll interview them separately.
Why do you do that?
So their stories aren't tainted or they don't, what's the word, influence someone else's story. You want them to be their own.
Taint is a good word.
So you're going to try to separate the witnesses and talk to them as soon as you can to get their freshest recollection.
Correct.
And in the old days, before body cameras, did you have a notepad? Have to take notes?
Yes, sir, I did.
In the incident that we're going to talk about, May 28th of 2023, you didn't need a notepad, did you?
No, sir.
And that's because you were equipped with body cameras?
Yes, sir.
Or you were equipped with one, but virtually all of the officers on the scene had body cameras as far as you know?
Yes, sir.
And so, how did you come to find yourself at this scene that you're here to testify about?
Dispatch was notified of myself and the other deputies working on my shift at that time of an incident that occurred.
Okay. And that was an incident at 7441 Park Lane?
Yes, sir.
And do you recall that to be an intersection of Park Lane Road and Spring Tree Road?
Correct.
Does that sound right?
Yes, sir.
There was a gas station on the corner?
Yes, sir.
So from the time that you got the dispatch, do you recall, and this has only been 3 years, and I understand that, but do you have a recollection of how long it took you to get there?
At that time, I was on the 77 end of Decker Boulevard, and it took me running code or blue lights and siren.
Pretty quick.
A short time to get there.
Okay. And can you describe the scene when you arrived there?
When I arrived, there was a lot of people there, and I was trying to figure out who was going on with them. There was a gentleman laying in the grass. There were people around the gentleman, and I believe fire and EMS were already on scene.
How about members of your department?
There was one other deputy that was on my shift.
Do you remember his name?
Deputy English.
Okay. Was he? I mean, you were working in his department. You all were working together, so you knew him.
Correct.
And do you recall what roughly he had accomplished by the time you got there?
Well, we both pretty much got there about the same time. He was just a little bit faster than I was. He started already, had crime scene tape out. He was what I call securing the crime scene, or preserving what he's being told at that moment, trying to establish what was going on.
The things that you've discussed before, the priority actions by officers arriving at the crime scene, you had a number of people there and you had a potential crime scene. What measures were taken that you recall to, as you described, preserve the crime scene or segregate it?
Once I was advised of potential evidence that was consistent with what the stories I was being told, the important thing was to make sure that piece of evidence was not removed unintentionally, because it could have, its location could have easily disappeared. So we moved the cars, we put crime scene, we expanded the crime scene area.
Put tape up?
Yes, with tape.
Crime scene tape. And that's a perimeter or a way of roping off the area?
Yes. And there was information of a bag that was thrown off. I guess it was a drain, a culvert, right there off the road. So
let me show you. State's Exhibit 12 is this. Does that look familiar?
yes.
Is that the black bag? Or
Yeah, that appears to be the bag.
Okay. And you were telling us where that was located. Where was that?
It was in a, I guess, I'm not going to say grassy, it's the growth off the side of the, it's where all the stormwater drains off in. And so it was kind of sitting down off a bit.
So this crime scene was off of a curved roadway.
Yes.
Spring Tree. And so there was an area without any particular vegetation and then a tree line behind that.
Correct.
Seem familiar? And before, well, this culvert that you're describing, was it a paved culvert?
I think a portion of it was. Then there was concrete. I mean, it was.
But it, just for the jury's benefit, and I don't want to put words in your mouth, but it may be easier to just ask you, it started at the roadway level and then it went up or down?
Down.
All right. It went down to a creek?
Yes.
And did you find that, or was it pointed out to you, this bag?
It was pointed out. I can't recall where that information came from.
Do you recall how far down the culvert it was?
It wasn't that far.
5 feet, 10 feet?
10 feet.
It wasn't in the creek?
No, it wasn't in the creek.
Okay. And where was Mr. Chow, this gentleman over here? You didn't notice Chow at the moment you arrived?
No, sir, I didn't.
You learned who he was during
Correct.
the investigation. And you had occasion to be involved in an interview with him, is that right?
Yes, sir.
Where was he when you arrived?
When I first made contact with him, he was standing on the sidewalk right above where the piece of evidence was.
And during the time you were there, did you have interaction with a young man named Andy Chow?
I did.
And did you learn he was the son of Mr. Chow?
I did.
Did you learn that he was somehow involved in the incident as a witness, or? somehow involved?
I did.
And you were involved in an interview with him?
Yes.
All right. And where was he when you arrived, if you recall?
I don't recall.
All right. Well, during the interview that was conducted with your participation, and we're coming to that in one moment, where was Mr. Chow's son when you and another officer were talking with Mr. Chow?
He was down, he was closer to Park Lane on a big sidewalk.
So he wasn't standing there listening, he wasn't
No, sir.
participating in that interview. And now, the interview of Mr. Chow, how many times did you speak to Mr. Chow in an interview setting?
The only time I interacted and spoke with Mr. Chow was when he was standing on the sidewalk.
All right, all right. And who began the discussion with Mr. Chow that you then walked up to and participated in?
Deputy English.
Your Honor, at this time, and so was there a point in this interview with Investigator English that you were standing there next to him after a point of, he had started before you walked up, is that correct?
Yes, sir.
And so at some point, as Mr. Chow was speaking, Investigator English went over to talk to someone else and you remained?
Yes, sir.
And so let me do this, if we may, Your Honor, we have talked and we would like to show the interview that's already been admitted. It is the interview on scene that Mr. English conducted with Mr. Chow with this gentleman participating. It takes 3 minutes, Jim?
Okay, so they want to show the first part of the conversation and then probably the second part as well.
So if you'll watch this.
Defense says the conversation spans 2 body camera recordings.
Yes, involved.
I can tell you what happened. He shot drifted in my store. I said, you follow him out? I followed. On the way down here, we tell him to drop at the store. I think it's a train song. I think he went over here. He checked the issues around here. He stopped to pick up. By the time he got up, my son had dropped it away. And then he waited about when he went up here. My son saw a gun and was there. He's got a gun. So I took my gun. I told him to drop it. He continued to run with the gun. And my son, his arm, I was behind him. He was dropping in my face. So I fired one shot. If we find 45 something. Okay. I fired one shot. So that's your gun? It's my gun. It's my concealed weapon. Okay. Well, he's when you fire a shot? Huh? He's my son saw. I didn't see it initially. My son. So when
So you recall much of that?
Yes, sir.
And that's accurately portrays what occurred?
Yes, sir.
And where were you in that video, just for the jury's benefit? Was that you on the right side of the screen?
Yeah. Deputy English was, that's the angle view. I was standing beside him on the right.
And during that period of time, when you walked up to participate in the interview, your body camera was activated and rolled?
Yes, sir.
And so, Your Honor, the second video, well, let's go ahead and offer that. Is our extracted evidence, or does it need satisfied?
It's already in the state's force.
That's what I was thinking. All right.
For ID. So it's up here.
All right, I would offer then
See if the state objects.
Authenticated twice.
Any objection?
No
All right,
objection.
Investigator Carter's body cam footage will be admitted as defendant's floor without objection.
It's interesting that Mr. Chow says he shoplifted in my store, and as we were following him down, we yelled at him to drop what he stole. To drop what he stole. So when he's yelling, drop it, drop it. Drop what he stole is what I heard. Not drop the gun, drop the gun. He also said, my son saw the gun. And then he sort of says, well, I also saw it.
The video we just watched was already in as a state's exhibit. Is that
That's correct.
Okay, maybe I misunderstood. What we now, like, you have seen your body camera footage outside of the courtroom this morning, or today.
Yes.
And so you authenticated it to me, and I discussed with the solicitor's office that this is his body camera footage. And is it correct, investigator, that your body camera footage does not include a little bit of what we just saw, but it picks up in the middle of it and continues until the end of your interview with, or your interview of
Yes.
Mr. Chow?
Yes.
All right, just so nobody's confused about what we're watching. So is it correct that what we're watching are two overlapping videos, two body camera videos, one of English, yours is the second one, of one continuous process of discussion with Mr. Chow. Is that correct?
Yes, sir.
But English departed at some point, and that's when you step up. So let's see that, Your Honor.
Let me, just before, we did talk about it, Sean. I just noted this is almost a 4-minute video. Are we playing the entire 4 minutes?
4 minutes?
That was not my understanding.
No, I think we're playing only, I don't know how long it goes, but we're playing only so much of the this body cam footage that is his interview of Mr. Chow. And I think that goes 4 minutes.
What will be admitted into evidence then? Is my question, Your Honor.
Well, Your Honor, we'll stop it and redact it, but I thought we had that. What? It's all his interview? Yes. Well, Your Honor, apparently this body camera footage of your interview with this gentleman is 4 minutes.
I'll stand ready as long as they can pause it. I'm sorry, I hate it. Maybe just approach it really quickly on. Sure.
All right, so this argument back and forth, this is the second body cam that was fought over extensively at the beginning of the trial during the state's trial. Defense wanted to bring this in under objection under the rule of completeness, saying we should be able to show this because it's relevant. It's continuing that same statement that was made. The officer just walked away. Now it looks like we're going to be watching all of this, which will give us the rest of the interview as it occurred.
All right, Investigator Carter. A little earlier, we showed you out of the lobby the footage we're about to see, and it's only all we're offering is your interview, your body camera footage of the balance of the interview with Mr. Chow. That's what you watched outside, correct?
Yes.
If we can begin.
So I one shot. You fired 45 is mine. So I one shot. So the shooter is my gun. It's my concealed weapon. Okay. Well, he's when did you fire a shot? He's my son saw. I didn't see it initially. My son alerted me that he had a gun. So when I lowered his hand, he actually had a handgun in his hand. So
in his hand.
As my son was trying to be worse when I came to jog it, and he didn't fall. So let's back up. So why did y'all try to do? He shoplifted my store.
He shoplifted my store.
My son chased after him.
I chased after him. I followed him.
So we went all the way down the street here. Where about? Yeah, he has a gun.
Then he got up and started running.
Mr. Carter, now that's can you, gosh, I don't know that it's necessary, but it might be helpful. Do you mind stepping down for 1 second? I'll hand you the little pointer we've been using. The area that we were talking about at the beginning of your testimony, this culvert where the backpack was found, State's Exhibit 1, can you point to that area where the culvert begins?
In this right here.
And so, as you testified before, the bag itself would have been, there's a hill there that would have been down the hill some distance.
Right, it's slanted over here.
Okay. Thank you, sir. Have a seat. You can just put that up there. I don't think you need to be strapped in. You're comfortable up there without that seat belt there. All right, let's resume.
What is your gun look like? Mine's a Glock. I'll be here. If you want to have it, I can. You got it on me? Yeah. Yeah, we're going to keep it. You want to get it? I can go with it. You want to get it? So I'm just going to get lost of suspects. I'm fingerprints on that because I actually move it away from it. I talk to them. And what caliber is that? It's a 45. You're not a 45 case. Okay, I shot it. So, what we do is, okay. Show me the picture. My son, get up to I'm telling you the same story. Yes, sir. We went down the street. On the way, I became the doctor. I didn't go back. He didn't. So he should focus somewhere around. I guess the train is over there. There was something else. He got a gun. So when I watched, there's a gun in his hand. What did it do? Not at me, I'm behind, it's my son. I mean, the gun is facing him. Did he survive at least?
All right, Your Honor, this would be so, Your Honor, this has been properly authenticated. Is that your body camera footage?
Yes.
It's a little late for that.
Accurately reflects the conversation you had with Mr. Chow at the time?
Yes, sir.
So, Your Honor, we would offer this as a defense exhibit.
It's in evidence as for.
Well, I think the first thing that you ruled in evidence was an excerpt of what is already in evidence as a state exhibit. This is a defense exhibit. This was not in evidence.
This is the defendant's exhibit 4, which is already admitted.
Okay. I missed that. All right.
I mean, you need to get up here and get it marked. Okay.
Okay, so it's been approved. All right, thank you. Now, subsequent to that interview with Mr. Chow, did you have occasion to interview Andy Chow?
Yes.
All right. And that is also captured on your body camera?
Yes.
All right. And between the time that you interviewed and spoke with Mr. Chow and the time that you interviewed Andy Chow, which interview occurred first in time?
The interview with Mr. Chow.
And do you know what period of time later, how much time between the two interviews?
I couldn't tell you specific.
Did you notice they're talking with each other, getting together?
I did not.
And Your Honor, so you have viewed outside a few moments ago your interview of Andy Chow.
Yes, sir.
And did the interview on your body camera footage. That was your body camera footage, yes?
Yes, sir.
And was it accurate, complete, as far as you can tell?
Yes, sir.
You see that? And Your Honor, we intend to offer this. He's authenticated that this is, I'm not sure where we are on defense exhibits 5.
How do you get around hearsay?
7. That's why I went to law school. I'm not very good at numbers yet.
I am thoroughly confused.
Well, Your Honor,
What number is this?
This is 7. Defense 7. This is the interview you have reviewed outside, which is your interview with Andy Chow, which is not no.
Judge is confused. We're a little confused. They're trying to admit the body cam of the second officer, which is an interview with Andy Chow. You have no audio.
Pre-published that one, maybe out of order, but I would ask that this be admitted as his body camera footage authenticated by him, and I'll be allowed to have it marked, and I'll be allowed to now.
Or not.
Exhibit it.
Any objection, Mr. Scott?
Just because, what number is this one at?
That's where I'm confused.
Yes. Number
5. I thought we were on 5.
That's what I
Someone
thought.
up there said 7.
How many?
No, just got
Confusion is just numbering right now.
Okay.
No objection. What you're about to show is number 4. Put in.
I do not believe so.
4 was the one we just saw with Rex.
This one is a body camera by Mr. Carter that was not able to be introduced without his presence.
I understand. I'm just trying to figure out the number.
The judge is like, I don't care what it is. I just need to know what the number is. The evidence identification number. Is it 4? Is it 5? Is it 7?
All right. One, Andy Chow was marked as 4 for ID purposes during Mr. Andy Chow's testimony.
Well, let's see.
And I admit it.
The video you're about to play is 7.
It's 7.
Okay.
I'm happy with 7, Your Honor.
All right. You'll be admitted to
7 works.
7 without objection.
Okay, John, without objection, number 7.
Okay, may we publish?
Yes, sir.
Okay.
I don't want to go back through. I think we go back through again.
So I was at the register. I thought he had pocketed like a water or something. So we told him to take it out, and he just kept his hands in the pocket. So then after that, he started going out the door, and so we chased him. He threw his stuff out at that corner there, and he was running back down this way. And then I caught up to him once, and then he kept going. He tripped right here, and then that's when I caught up to him. And where my dad is right there, I caught up to him like right here, like standing right next to him. Or not like standing, I was like running next to him, and that's when he had like pulled out the gun. And then I yelled gun, and I like backed up, I like stopped. And that's when my dad like was yelling stop, like drop it or something. And then that's when my dad, he didn't just drop it. So my dad shot him. And then he dropped to the floor. And he was like, you know, kind of like holding his back or something. And then he had dropped the gun, so my dad like pushed it to that second tree over there. And then he was still on the floor unconscious. And then we called 911. And around that time, that's when like the people had come down like that parking lot. And then the white woman, she was EMT, so she came to, and that's when we noticed he was unconscious. So then she did the like tourniquet and was doing CPR. And so then I left because I heard the sirens. So I went down to the parking lot, and then they started parking like on the outside on Park Lane. So I was waving them to come down here. And then after everyone, most of the cars had come down here, I came back. And then you guys had already started putting up the tape. So then, I mean, I just didn't hear this time. Yeah. Okay.
Check with the sergeant and then
All right. And so, other than you, when you left the scene that evening, you had no further involvement in this investigation, is that correct?
That is correct.
Thank you, sir.
Thank you. Anything on cross-examination? No, sir. All right, sir. You can step down. Thank you for being here.
All right, defense.
No. We need that too.
Mr. Chow?
I think so.
Yes, Your Honor. Thank you, sir.
All right. Thank you. Investigator Clark.
Mr. Chow is shackled right now, so he can't be led up in shackles in front of the jury if he is going to testify.
Call your next witness.
Thank you, Your Honor. Defense called Shelby Bradwell. She's walking in, Your Honor.
A little sidebar behind the bench. That's the most sidebar of sidebars I've ever seen. The one witness that was described at the scene and seen on the body cam that we have not talked to is the lady that was described as the white lady, the EMT. This might be her. She was seen in a this is a police officer. She's wearing a sidearm.
Do you swear or affirm the testimony you give in this case will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please have a seat. The witness stand and state your full name for the record.
Shelby Bradwell.
Shelby, if you'll spell your last name for Madam Court Reporter for me, please.
Bradwell.
Now, Shelby, I'm going to ask you some questions, and I go over rules with everybody so we can understand and be on the same page, okay? And that's the first one. Madam Court Reporter is taking down every word that you're saying, so she cannot take things like and head shakes. Can we make sure we can speak loud and affirmatively so she can get down every word?
Yes, sir.
Number two, and that's the second one. She can't take when we talk over one another. So if you'll allow me to finish my question, I'll give you plenty of opportunity to answer the question. Is that fair?
Yes, sir.
And at some point in time, and she will tell you also, I've been known to speak way too fast, and sometimes it's hard to understand my questions. So if you don't understand it or don't ask understanding questions from anybody else, if you'll ask them to repeat, they'll repeat their question. Is that fair?
Yes, sir.
Okay. Shelby, first of all, if you'll let this jury know Who are you? Where are you from? A little bit of your background. Just let me know who Shelby is.
I'm Shelby Bradwell. I'm originally from here. I am a deputy sheriff for Fairfield County.
And before that, what did you do?
Before becoming a deputy sheriff, I was an EMS student and I did security for a hospital.
And you were here under subpoena, is that correct?
That's correct.
Ever testified under oath before?
No.
So we'll do this together. Take your time and breathe, and we'll get through it. It won't take very long. Shelby, we have seen you on some of the body cam footages. Will you tell the jury about what you did, and you know what case we're here. So if you'll let the jury know, what did you do about the case that we're talking about today? What was your role?
So basically that day, I was a civilian and I stopped and provided CPR to Cyrus. Whenever I pulled up on scene, I noticed that there were 3 individuals. I pulled in the parking lot of an apartment complex right over there. I ran to where those 3 individuals were. I asked if help was needed. They stated yes.
Let me slow you down real quick. Using words like pronouns like they and so forth. Do you know who they were who asked that they needed help?
I asked Rick Chow and his son.
Did you know them before this?
No.
Were y'all personal friends or anything of that nature?
No, sir.
And so I got your testimony. You were just happened to be driving by.
Yes, sir.
And again, when you were driving by, what did you see?
I seen 3 individuals on the ground to my left.
Okay. And then that's when you stopped your vehicle.
That's correct.
And now let's go from there. And so what happened at that point in time?
Whenever I went over there, I asked Rick Chow and his son if they needed help. They stated yes. I then told them that I was an EMS student. Rick Chow's son, he moved out the way so I can get on the left side of Cyrus. I then checked for a pulse. I didn't feel a pulse. So I started doing chest compressions. And then as I was doing chest compressions, Rick Chow was doing mouth to mouth. And
this is something you were watching yourself, like the 2 of you were there.
Correct.
Was anyone else around the area while you were doing this that you saw?
I don't really remember. Okay. I was just focused like on Cyrus at the moment.
Okay, so go on.
As I was doing chest compressions, he was doing mouth to mouth. He was sucking the vomit out of Cyrus's mouth, and he was spitting it to the side of him.
Hold up. Let me go through that again with you. What do you mean he was sucking the vomit out of the young man's mouth?
Cyrus had vomit in his mouth and his airway, and he bent down and put his mouth over Cyrus's and was getting the throat out.
As he was doing the mouth resuscitation?
Yes.
Have you ever seen anyone do anything like that before?
No, sir.
Did this just happen one time?
No, he did it multiple times as I was compressing.
You ever seen anything like that?
No, sir.
Was he, from your impression, trying to save the young man's life at this point in time?
I think it's fair to say that.
Okay. And what happened then as he was doing this on multiple occasions?
He kept spitting it out, and then it was brought to my attention that Cyrus had been shot, and I didn't know where, so they rolled him over and they showed me his back, and I seen the entry wound, and whenever I seen it, I took my shirt off and I was going to apply a tourniquet. However, I then remembered that you can't apply a tourniquet to the abdomen area. So we just left my shirt be. We just left it up under him, rolled him back over, and I kept doing chest compressions.
Okay, and did you see during this time Mr. Chow having a conversation with his son or talking about getting their stories together or anything like that?
No, sir.
And so all you were able to witness is when you got there, Mr. Chow and his son there together.
That's correct.
And the older Chow was helping you perform mouth-to-mouth on the young man at the time?
That's correct.
and I want to make this clear, you're not saying he was clearing his airways or clearing the vomit out with his fingers and throwing it out. That's not what you saw.
No, he was using his mouth.
As he was doing the mouth-to-mouth resuscitation.
That's correct.
And so he was doing it, the vomit would come out, he'd spit it out, and then go back and continue to do mouth resuscitation.
Yeah, he was, as I'm compressing, he was over Cyrus the entire time, like his mouth, and he was just sucking it and spitting it to the side.
Thank you. That's all the questions I have. Thank you so much.
Anything on cross-examination?
That's basic. Not on the neck, not on the abdomen. It has to be on an extremity.
Ms. Bradwell, so it's true that you didn't actually see the shooting, correct?
That's correct.
And you didn't see any of the events that led up to the chase, correct?
That's correct.
And you mentioned that there were 3 individuals at the scene when you got there, right?
That's correct.
One was the defendant, Rick Chow.
Correct.
And that was one that shot Cyrus in the back.
I don't know if that's who shot him because I didn't see the shooting occur.
Okay. Did someone tell you that Cyrus was shot in the back?
Yes.
Did they tell you who?
Did they tell me who shot Cyrus or that Cyrus was shot?
Either one. Just object because the figure say nature of confrontation, who shot.
Okay. And was one of the 3 individuals the kid Cyrus?
Yes.
Okay. One was Andy?
Yes.
Okay. So did you talk to Andy on the scene?
When I first arrived, whenever I was asking, do they need help and stuff. But other than that, I don't know who told me that he was shot. They was just like, he was shot. And like I said, my main focus was Cyrus at the moment, so I don't know which one of them told me that.
Okay, so but you did talk to the younger child?
That's correct.
Okay. And was this when the little boy was still on the ground, laying on the ground?
Yes.
Okay. And had police arrived yet when you talked to Andy?
No.
Okay. When you talked to him before the police arrived, did he ever tell you that the victim pointed a gun at him?
No.
Did he ever tell you the victim pointed a gun at him minutes before that?
No, ma'am.
When they asked you to go help the little boy that was shot on the ground, did Andy ever tell you, be careful when you go over there because the kid just pointed a gun at me and tried to shoot me?
No, ma'am.
No further questions.
Just briefly. Very briefly. You weren't there as a police officer, correct?
That's correct.
Weren't investigating?
That's correct.
Weren't interviewing anybody?
That's correct.
You were just there as actually a concerned citizen?
Correct.
Thank you so much. Thank you for your time, Shelby.
Anything else?
No, you're on.
Thanks for being here. Take a break. All right. Ladies and gentlemen, we're going to take a break. I got a matter of law I need to take care of, and we'll be back with you as quick as we can.
We may be hearing from Mr. Chow.
Okay.
One of the reasons we take a break at this point is if Mr. Chow is getting the shackles removed from his feet prior to walking up to the stand. Let's see if that happens. Attorney keeps looking down at the shackles.
Okay.
Pointing at him.
Is Mr. Chow going to...
Can I just confer with him a moment?
Yeah.
It's a last-minute decision. Lawyers asked to confer with Mr. Chow to see if he's going to testify. If he doesn't, they may rest right here. Taking the stand is crazy. I agree. I don't think they're going to go all the way up to closing arguments today. It's got to be Monday. This is East Coast time. There's Mrs. Chow on the end there. believe he's in custody.
Is Mr. Chow going to testify? Do you plan to testify in your own defense, Mr. Chow?
No, I don't.
No.
Okay, very good. All right, anything else from the defense?
No, just other than what I discussed with you before.
Okay, and so the defense rests?
Yes, Your Honor.
Okay.
Defense will rest at this point.
Defense will rest in front of the jury.
Will there be any reply from the state?
Any rebuttal?
No, sir, I don't believe we have.
No rebuttal. We're
Okay,
done.
well, if there's nothing further, obviously not going to try to argue and charge today. Why don't I, if y'all have no objection, I'll just go back there and release the jury for today. You need to rest on the record, that's right.
No, I don't need the rest. I mean, the defense rests. I mean, did you want me to do it in front of the jury, or I don't?
Let's do it in front of the jury, just to keep safe, to make sure proper procedure is followed. All right, Mr. Colbert, bring him in, please.
So we've got a poll up now that all the evidence is in before the jury. Did the state prove the case against Mr. Chow? The first answer is no. The second answer is yes. Answer carefully. Read the answers carefully. Put it in bold so it's easy to see. Greeners is voting for a write-in. Interesting, listening back to that audio from the body cam that we just had played with Mr. Chow. He says he didn't see the firearm, but his son did. And he also said that the gun was in the victim's hand when he fell and pushed it away. They're also clear that he also says that he yelled to say, "Drop it, drop what you stole." Interesting variations to the story. I know a lot of you want a third option on this one, but unfortunately, the jury only has those two options: guilty or not guilty. Appreciate a couple of you have sent some laws regarding the shopkeepers law in South Carolina, which does protect shopkeepers on their property. It's specifically what it's written for, and it does strongly warn shopkeepers about having very limited protection once they leave their property. It's still, the actions they took were not illegal. They were not endorsed or codified in law as legal options for shopkeepers to take, but it wasn't illegal, which I think it would have to be for it to count as instigation. Hang on, my wife's calling me.
Your Honor, if I may? Yes, sir. I know you give the normal admonitions, but seeing that, just again, the nature of the matter that we're dealing with right now, just the normal admonitions to the jury about the scene and social media and all the other stuff, and just reiterating that so we can keep them as pure as possible.
Okay.
Thank you, Your Honor.
I'll do that.
Thank you.
Just present, John. Thank you, Mr. Colby. Anything else from the defense?
Your Honor, after reviewing all the evidence presented by the defense, speaking with co-counsel as well as Mr. Chow, at this point in time, the defense choose the rest of the case.
Very good. State going to have anything in reply?
We do not, Your Honor.
All right. Well, ladies and gentlemen, that concludes all the evidence in the case. It is 3:20 on a Friday, and we still have some legal stuff to do. Believe it or not, they probably won't agree on the law that I'm going to have to charge you on, so we're going to have a charge conference that may be rather lengthy, and I'm not going to take a chance of y'all getting this case at 5:30 or 6 o'clock on a Friday afternoon. So I'm going to excuse you for the weekend. Again, don't discuss the case with anyone. Don't discuss it amongst yourselves, your family. Don't do any research. Stay away from any media coverage of the case. Don't do any, again, research on your own, like going to the scene or anything like that. We want you to come back in Monday fresh and with an open mind, and we'll have all our legal stuff ironed out, and we'll hear closing arguments, and it'll be your turn to get work. So, with that being said, enjoy your weekend. But again, just stay away from social media, any media. I don't want anybody to be in any way tainted when you come back on Monday. Also, nobody is entitled to get sick over the weekend. We can't afford to do any more to it. Just kidding.
Don't get sick.
Anything else from the defense?
Nothing on behalf of Mr. Chow.
Listen.
Nothing on the stage, Your Honor.
All right, y'all have a good weekend, and we will see you Monday morning at 9:30.
So the jury heads out right now. We might have a charge conference. A heated charge conference, even.
All right, I guess we need to talk about the charge.
Yep.
Judge,
Yeah, probably right.
Judge, we could review our motion for direct verdict. You want to do that now?
Yeah, you can go ahead and do that.
Judge, renew the motion for direct verdict made at the conclusion of the state's case. Ask you to incorporate the comments and arguments that were made at that time and renew them.
Okay, I'll note that for the record, and for the same reasons that closed the state's case. All right, so we need to talk about the charge. Obviously, there would be a charge of murder. Is there going to be any necessary includes requested?
Your Honor, this time, well, I didn't. Can you hold on? Judge, can you hold on?
Yeah, y'all. You want? Let's take about a 10 or 15 minute break. You want to do that? All right, we're going to be at each about 10 or 15 minutes. Y'all just consider lessers, what defenses are, the couple areas where the two sides normally disagree, and then we'll go from there.
I'm sure we'll disagree.
I would expect nothing less.
It'd be nice if they could work out the details on this one. Because we got a 15-minute break now. It would be nice if they could work out the details here. We just argue about the issues where there is disagreement. Obviously, it's going to be very important that for the defense that they get included in jury instructions that talk about the rights that Mr. Chow had regarding self-defense and defense of others. The state's going to be looking more to probably talk about the instigation of the altercation and say because they chased him off the property, they didn't have those rights. They had then started the altercation and are not afforded the right to lethal force in self-defense when you started it. So we'll see how this goes. Flight to Catch attorney with the light-colored suits? Yes. He's a great guy. Kent, I think is his name. My wife called me to let me know that our neighbors have their house under contract. Like, we didn't know it was up for sale. But it's under contract now, so yay. Chow's saying defense of others. And he didn't have to testify because they were able to bring in that body cam. And the body cam is where he says, my son said he had a gun. I was backing away and I shot him. This is RA After Dark. No. The jury's going home, so we're not going to be staying late today, but we will work a full day. Probably this jury instructions will take a bit. Closings most likely on Monday, according to the judge, as long as we can get things sorted out today. Forget the water. Focus on the final few minutes. Yeah, this is what I don't think it's fair to look at this and say they shot him over a bottle of water. I think that's an oversimplification of the facts. Which isn't fair in the situation to either party. But it sure doesn't look good. It sure doesn't look good when you lay this story out and see how it started and see how it ended. There's a line in Anchorman. It's like, wow, that escalated quickly. Yeah, this escalated quickly, and it went from 0 to 100 in no time flat. I believe the shot in the back and chasing the gate self-defense. The chasing might. Depends how the law is interpreted here. The chasing might. But the shot in the back in and of itself, it's bad. If it was just one person, it would be bad. I've got a call trying to come through, and I've rebooted my phone. Let's see if this will work this time. Yes. I answered. Okay, and they hung up. We'll have to call again. The shot in the back is not a problem in and of itself. If it were just two people, a victim and the defendant in this case, and the defendant had shot the victim in the back and nobody else was there, it would be very hard to say that's self-defense because it's clear they're running away. Where there's a third person involved in this, and the altercation is between the victim and the third person, you can have defense of others, which is just as strong a defense as self-defense, and that can apply.
Call from Angela.
Angela, I fixed my phone. Thank you for your patience. How are you doing?
You're welcome. Thank you. I'm doing good. You?
Good.
I think I got my hearing back, but we'll figure that out later. I hear you. That's good.
You and loud music.
Oh, it's more than that. It's way more than that.
Yeah.
I'll first say what I in regards to this case. I think. I think that I'm guilty, but also not guilty.
Explain their rationale for both, because I do want to hear.
I don't know. There is yes, he did some stuff wrong. He had no right to chase after him. As soon as the guy exited the store, close the door, lock it up, and wait for the police. So I don't know. That's where I'm guilty, not guilty. Okay. Why did he? But I was mostly following this case in rewatch crew because I was neck deep in writing a paper, which we are hopefully going to be done. That's the point. That's the goal, to be done on Sunday and turn it in on Monday.
Let me stop you. The paper sounds fascinating, but let me stop you just a little bit. Would it matter? I'm not sure if you heard this. Would it matter if the lead investigator on the case said that them chasing Cyrus was not illegal, but they had to use common sense?
That's what I am, both guilty and not guilty.
I agree. They did not have a
know.
right to chase him. They aren't protected under the law. This is the gray area. That's why there are charges, right? There's not a statute that says if you think they stole, you can chase them until you catch them. Never let them out of your sight. You have the right now. Nothing like that exists on the books. But there is also not a law that says you can't. What they were doing was not explicitly endorsed or illegal.
That's kind of like the topic of the paper I'm writing right now. It's not illegal, but yet you'll lose your license if you do it. You know.
It's definitely not recommended. It's actually recommended against by the police, and in that the explanation about the shopkeeper law itself.
Reasons.
Yeah, they said chasing someone greatly escalates the probability of the violence escalating, of the outcome escalating. That's what it says.
Yeah. So that's why I am like in between guilty and not guilty. I guess the jury has to like overcome that burden, like figure that out, that part. I guess that's why there's like jury instructions to like get over that fact, whether or not they think the jury instructions to help them decide one way or the other. Like, I don't know. And all the facts, of course. Yeah.
Well, it makes you think. It makes you think, and I don't envy the jury. I would say that I'm fairly secure in where I stand right now, but I'm not 100%. Like I'm not 100% not guilty.
You know what's that? There's like reasonable doubt. So we should vote guilty because we are in between guilty and not guilty. That's reasonable doubt. There shouldn't be like not a scintilla of not guilty. If there's like a scintilla of not guilty, then you vote not guilty because it should be like 100%, not 99.9%, but 100%. Sure.
Yeah.
So yeah.
Beyond reasonable doubt.
But. Yeah, I am actually calling out also for another reason, and something, a tradition that something nice, and why I'm kind of hopefully getting my all 100% of my hearing back this weekend, unless they do it again, which I hope they don't. But there's like a tradition here in Sweden that the graduation season has kicked off. And today, PhD students graduated, and they have a tradition where they have like this whole ceremony that is live streamed on YouTube, which I sent link in the Discord if you want to check it out. If you don't understand it, it's apparently mostly in Latin. So
you didn't understand it either. Okay, good. No. Nobody understands. It's just traditions. What we do.
Nobody understands. Okay. Yeah. Unless you speak Latin, of course. But you may also see cannons firing because there is a tradition where they fire cannons. You know the military grade cannon? Okay, maybe not military grade.
I'm thinking like the 1812 overture, like the symphony, like da, 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 that song, I think. And I don't know what that's. No, that's a different one.
Okay, we're talking about two whole different things. Cannons, the real like
boom.
Those
fire,
things.
smoke,
and they and I was 6 minutes walk away from there, and it's a hot day. Of course, we had windows open in the room where me and my group was sitting and working on our paper. And when we heard the first one, it scared the crap out of us. You know, we were like, "What's going on?" You know, like you were there sitting, writing the paper, discussing what you were going to write, and all of a sudden you hear a boom. You know,
I tell you, you have to get closer. You've got to be right up there. I mean, not in front.
Oh,
I've filmed a lot of cannons being fired for demonstrations, Civil War cannon replicas, stuff like that, where. I've even had cameras in front that just get knocked down by the blast of the shockwave, even though it's not actually launching a cannonball. It's just like a dummy.
There's also a video of that in the server, just not that close. There was like a safety. It wasn't me who filmed it, so don't blame me for the quality of the video. It was someone else. So you can check it out. But they fired it 51 times.
They're just trigger happy.
Throughout the day.
They're just trigger happy. They can, and so they.
No, apparently it's a 51-year-old tradition, so they fire it for every year. So next year is going to be 52 firings. It's going to be fun. I'm going to make sure I'm not in the city or like a safe distance, like not earshot.
Your great grandkids are just going to be like, when will it stop? They've been going for 3 days now. Angela, I've got to go back to the topic here at hand.
Sorry, I'm so sorry. I'm so sorry. But yeah, back to the topic. I'm sorry for dragging out sorry for dragging. I am. It's going to be interesting to see how how long the deliberations will take, and I'm looking forward to this charge conference to see how much they will argue.
We'll get to hear the law, the latest version of the law explained, which the judge is going to explain to the jury, and I think that's going to be critical in deciding this one. But Angela, thanks for the call. I hope your hearing comes back. We'll see you. Bye. All right. Donald King says, what I sent you said the shopkeeper may detain a shoplifter, but it has to be in close proximity to the crime, and they have no legal authority.
Call from Allison.
Hey, Allison, hang on just 1 second.
Okay, sure.
They have no legal authority to chase someone off the property. I agree, 100%. They have legal authority. The law protects them as a shopkeeper under the shopkeeper law within their store, right outside the store, sometimes to their boundary. Very, very seldom beyond that. That's the protection. But they also were not necessarily prevented by any law from doing what they were doing. So that when the police say it's not illegal, but you have to sort of use common sense. That's where I was going with that one. Allison in Texas, how are you doing?
Ooh, I'm pushing back on that one.
Okay, go ahead. Go ahead.
I'm pushing back. So I'll get it out real quick because they'll probably come back. But earlier, someone called and recommended the Scott Spivey case. You really, if you have like downtime between whatever, Cat Not Williams covered. It's like a series, a couple days hearings. It's actually really good to watch, whether it's related to Stand Your Ground, but it kind of gives insight on how whether it's civil or criminal. It's kind of approached the same way, I think. So over the lunch break, I got sucked into the whole shopkeeper or merchant privilege thing, and I was looking it up. And so what is your stance again on the privilege if it protects, but it
law
doesn't, it gives them the
protects, in South Carolina, the shopkeeper's law protects the shopkeeper from those charges of unlawful imprisonment and kidnapping, things that people could charge if they were detaining somebody on their property that was shoplifting. The law in South Carolina also allows people to act on a mistaken belief and protect them in some way of that as well. So if you believed, like we used the example, that someone was beating the crap out of somebody and they were about to kill them and you shot them to defend that person they were beating, but what you didn't see was that there was a snake wrapped around their neck and that person was punching the snake trying to get it off them and save their life, that law would protect you in the charges that could potentially be filed for shooting that person wrongfully. So there's some protection there. So even though he hadn't stolen anything, they were acting on the belief that he did, and it was a reasonable belief. That's very important. It has to be reasonable. And this law that the We Too Low says is it's State v. Dickey in South Carolina. Once you pursue someone who is retreating, you lose self-defense claim because you became the aggressor. My understanding of that one, I'll have to read the case law again, but I'm a little bit familiar. I think that is actually about someone who is trying to withdraw from an altercation. And this could be viewed as someone who was committing the offense in their eyes. Yep. So I think it doesn't apply directly, although it's definitely something to consider. But go ahead, set me straight on wherever I'm wrong.
It really gets, okay, I'm going to set you straight. Now, you
Please
listen
do.
here. No, just kidding. So I got sucked into it because I was thinking, that can't be. But it is kind of gray because it only is what case law is. It's when a case comes up and they figure it out. And they say, okay, now this stands for that. But going back to Scott Spivey, it was very simple. The reason they didn't get criminally charged is politics and the corruption, and shame on Alan Wilson and Led, whatever, for not charging those two. But besides that, it's real simple.
The judge is
You're the aggressor. Oh, shoot. I'll call later then.
Allison, I want to hear what you have to say. Please do.
I do too.
Thank you so much.
Bye.
All right, bye. Allison sounds like she's got some great information there. I'm sure we're going to have more opportunity to talk about this here tonight. So let's see what they do. They came back a little bit. Well, no, that's right on time. 15 minutes went fast.
Yes.
Looks like they have found points of agreement, which is great. That'll speed things up.
No, we still talk about that. You can talk about the others.
Your Honor, we can, obviously, we're prepared to hear from you, but there is a consultation over here that really can't occur anywhere else.
They had to take him downstairs to go to the bathroom, so we haven't really talked to him.
Oh, okay.
That was the problem.
Okay. Not me. Give me a few more minutes.
Yes, please.
Pardon? You want a few more minutes?
A few more minutes?
Yeah, I'm
Allison, call back.
I imagine I know what it is, so take all the time you need.
Thank you, John.
Yeah, we'll give you
Yeah, that's all we need.
Okay, we'll be at ease.
We're at ease. The judge has not left.
Judge, can his wife come over here?
Judge gives permission for the wife to step up. That's interesting. I wonder if the sheriffs are cool with that. But sheriffs are like, whoa, you can't come over here. And they just said, we just talked to the judge. Sheriff says, no, you can't. He doesn't make the rules. I'm the bailiff here. Reading lips, he says no.
Allison. To accept.
Wow. Allison.
Yeah.
Got some drama spilling out.
Did they break? Because I can't watch it and call you because
They didn't break, but during the break, Mr. Chow went to the bathroom, and the lawyers didn't get to talk to him, so they're asking for more time. The judge is now giving them permission for the wife to come over to the area next to Mr. Chow, and the bailiff doesn't like it and said no, but the judge has authorized it. So.
Oh, he's nice.
Yeah.
Not
okay.
really.
Tell us a little bit about
I'm not a fan of the judge. Okay, Spidey. Well, I'll just go back to Chow. Try to get it in before they come back.
Yeah.
So the privilege to the shopkeeper, what I read, and I'm a reader of like the last 30 minutes, is they're mainly concerned about civil suits, right? Being sued, and it's like they can protect their property with use of in a reasonable manner, without the use of deadly force. Non-deadly force, okay? Right. And what you said about the property was kind of the limits. You know, I'm sure there's not really a hard limit, but so...
Yeah, it has words like near, has near, nearby, surrounding area, and things like that. So those are up to legal interpretation in every case.
So unless they write it into the charges or the instructions, it's not going to be applicable. I mean, it just cannot, because you have it... They're the aggressor. One thing that bothered me, and I'm all over the place, one thing that bothered me is maybe I missed it. Well, the big thing that bothered me is I couldn't stand the lawyers, how they were attacking witnesses, whichever side. It bothered me so badly. But oh shoot, I'm blanking. So they're the aggressor. He can defend himself too, okay? And usually stand your ground. Controversial, right? Because it's usually the person that shot first gets to live and talk about it, right? We stand their ground.
And standing your ground implies that you stand somewhere, not chase after someone, right?
Right.
Just
so they
chased
him, and they never asked. I don't think. Maybe I missed it. They never asked, like, okay, what were you intending to do when you caught him? I mean, I just never got the answer. Like,
they asked. What? They asked. The prosecution grilled Andy on that, and all he would say was, "I was looking to see where he was going." That's all he would say.
Yes. That wasn't
what were you going to do when you
an
caught
answer
him?
at all, right?
I didn't think about that. How far were you going to chase him? I didn't think about that. What were you going to do if I don't know. I just wanted to see where he was going.
Right. And he is a patsy for his dad. I don't believe him one bit. I mean, I believe he was not natural. I'm not being conspiracy, but for real, it was the only way his dad could avoid the stand was if he took the hit.
Okay, but
being the one that
let me play devil's advocate on that one for just a minute. What we have is almost immediately on the scene, he gives a matching statement to what he said today. He's been consistent across the board. They couldn't catch him on anything other than he said stop when he meant slow down. And it could be interpreted as I stopped running or I changed pace 2 times. He said he stopped at the corner and then he stopped next to him at arm's length away. And both times he says he continued moving but at a different pace in a different direction. Other than that, they couldn't impeach him on anything.
It doesn't matter. He was the aggressor. He was still the aggressor.
But I'm saying
they were still the aggressors.
testimony-wise, he's the first one. You mean he just thought up this story immediately and stuck to it, and it was all perfect, and there's not a thing that they could
saw
pick
the
apart?
gun at the scene. They saw the gun at the scene.
But this is like
first
Dexter
thing, cover
level.
your butt.
This is Dexter level.
No way.
Precision, though.
No way. No way. No way. But the reason I think that is because one thing I didn't like about this trial, the judge let all the attorneys, especially the defense lawyer, pretty much testify by leading, and it drove me crazy. It drove me crazy because the acting out and everything, it was like, this is what they did. They prefaced every introduction, each witness with, you can't correct me if I say anything wrong. So basically, while I'm asking non-questions and making statements of fact, if you don't correct me, they are what they are. And a lot of the stuff we're talking about is what the defense, or the prosecution, but mainly defense, stated as a fact of the thing when it was never put in except by their word choices. I mean, it just was like, this, and if you didn't correct them, and they didn't get a gotcha with the adjective or whatever, it was like supposedly written down on the books, and that there's no proof of most of that stuff. It was, somebody's viewpoint.
It is. It
But
does
Andy-
come down to a he said, she said almost situation.
Right, but they were still the aggressors. I mean, I just can't. It's like you have to step back, the broad picture. There's not a pass for them because they're shopkeepers, because they went beyond what was reasonable.
Shopkeeper law does not
And they
protect
didn't
them
have a definitive person. They're supposed to detain if they're on property. They can detain usually employees or whoever they suspect. They can detain them with non-lethal force.
That's under
no force,
shopkeeper.
actually.
We're not using shopkeeper
Right.
in this case, though.
Right. So that's my point. If we bring that in at all, that's the parameters. If you take it out, they are the aggressors, period. They had no permission to keep going. They had no objective. He couldn't even say what he was doing. Like, how do people see it? Okay, if someone's chasing you, take them out. Take out the shoplift. You can't bring in the shoplifting thing without giving them parameters, like giving them limits, because it's not limitless.
But
whether it protects civilly or criminally.
I agree. They have no protection, and they should and probably will be sued civilly and most likely be found liable. I think that's 100% right. This is a wrongful death. We've got a kid who shouldn't be dead right now, right? And he shot him.
Mm-hmm.
I think that will be squared away civilly. But where it comes to criminal, I don't see in the law where they couldn't do what they were doing. I see they strayed beyond their protections.
You can't be the aggressor.
What was the aggression, though? There's no contact.
They were
There was no
chasing him.
threat.
Yeah,
You
they were
can
chasing him.
run in public. We're talking
They
15
were
seconds.
chasing him.
They were.
No. They were chasing him.
They were.
And he was in fear.
But the testimony that came
that's
in
why
was
they kept bringing it
they
up.
were chasing him, saying, "Drop it, drop what you stole."
They can say they said that, but they were chasing him.
Mm-hmm.
He was in fear. He was losing items off his person.
Or throwing them.
It was one aggressor, one person fleeing. So there's another way to look at it. One was chasing, one was fleeing. If you're fleeing, you're not the aggressor. So you can flip it back. To me, it's very simple unless they try to bring in some kind of rights. And the only way they brought that in was asking kind of equate law enforcement to property rights. And that's silly, So then they got it through the detective, like saying, yeah, well, common sense. That was not evidence. That was not code. That wasn't law. It was just like, because nobody...
It was evidence.
They
I take
poorly
issue
object-
when you say there's no evidence or it's not evidence. If it came in on the witness stand from a witness, that literally is evidence. That is the definition of evidence.
He answered to a question the attorney put to him. He didn't say, it may be his opinion, but it wasn't like this is the law. I guess my point is this.
Yeah.
Unless they bring in some special rules into the charging or whatever you call it, it's going to be simple. It's going to be forget about the shoplifting. Of course, the jury can consider that like reasonable, but chasing, there was no goal. There's no goal other than you could assume the worst. I mean, there was no goal in product of it. They didn't call the police first.
I think defense, I don't think you have to. I think defense has some things on their side in that argument. They can say, first of all, no witnesses, 0 witnesses say that Mr. Chow was running down the street with his handgun drawn, looking for a chance to shoot. None of them
It was
did.
on his hip.
It was on his hip legally.
Well, okay. So he could have a hammer, he could have his fist, but
He
one
can
was
have 10
chasing and one was
guns.
swinging.
He can have 10 guns legally, and it's still not a problem. So even though he had the gun, it's not a problem. Chasing someone, even when you're carrying a gun, not a problem.
But you killed him, and you were the aggressor, so it matters.
And I think that will happen in civil court. The issue I have here is
I'm gonna bet you. Okay, sorry.
Allison,
I'm
you're
getting all
probably going to
riled up.
win. You're probably going to win this bet. I'm telling you. And I won't get into my reasoning for that, but I don't know.
So I think it's. Is it in the law? Is it in the? I have no idea. I don't know what South Carolina says. Is it say that you can claim self-defense unless you are the aggressor? And there's no duty to retreat. I know that.
Yeah, it's not. This is not a stand your ground issue. This is defense of others.
Says he didn't win that. He went to a pretrial with that, and so that got taken. Like he didn't get immunity on that.
By that, I believe the ruling was not that you cannot claim that. It's that there is enough evidence that the jury can decide that, and that will probably be argued in front of the jury. He can still claim and say, if you think this was self-defense, you would find this not guilty.
Right. It's just called self-defense. Yeah.
Right.
Instead of stand ground. But I'm not watching, so I don't see what's coming on screen. So boot me. If you have to.
You're good.
But I'm not gonna be long. So I really do think it's literally down to. I already said it. I don't want to repeat.
Allison, you've done a fabulous job. I love talking to you. This is great.
Anyway, listen. You need that when there's downtime and you're kind of court hopping and stuff. You really. It's Mark Tinsley is leading up the plaintiff's side, and he's
awesome.
Really good.
He's awesome.
It's like a soap
From the
opera
Murdoch case.
drama. It's great. Yeah, he's awesome. He's my favorite.
Yeah.
Like I had a crush on him. He was so good.
I think many of us did.
They had the hearings posted online. And any downtime, you should look into it. It's really entertaining.
What is this downtime of which you speak? I'm sorry.
You're court hopping. You're court hopping between the bigger cases. And I'm like,
I know, but
and I watch you all the time, but I'm like,
Oh, Allison, you are fantastic. Thank you very much.
because I'm just trying to make you do what I want, and that's all.
I appreciate that.
Okay. Have a good
I
one.
really do. Thank you very much.
We'll see what
Call again.
happens.
I can't wait to
bye.
talk to you again. Bye. Allison's great. Agree with Allison. She's fabulous. That was a wonderful, wonderful call. I appreciate that. And I like that she stuck to her opinion and argued it very effectively. Very effectively. I didn't have a crush on Tinsley, says Josh, but anyway, I said many of us. I'm not saying that I did either. We might have been the only two who didn't, but many of us liked Mark Tinsley from the If Y'all Got a Crush. Also, Janet didn't. So the three of us didn't. Other than that, it's good. I need to hear from Allison more. She thinks clearly. Litigator, I love it. I do. She's fantastic. So confused. Don't be confused. Don't be confused. I think it's perfectly okay in this situation, and we're going to end the poll in just a minute, but I think it's perfectly okay in this situation to have watched this case, even to watch all of it, and just not know where to end up, and or to have a mixed feeling, or to have started one way and now felt a different way. I think that's perfectly okay. Allison, I think if we were to do a poll right now, who is more correct, Allison or RA? I think you would win, and it would be a landslide. We're ending the poll. And did the state prove the case against Mr. Chow? And the results, yes, guilty 58%, no, not guilty 42%. So just a difference of just 16% between the two. Is that right? I think so. You can't use defense of others again if you or the person you're offending incite or provoke the confrontation. I'm with you, Donald. I'm just saying that under the acting under mistaken belief doctrine, which does not give them the right to chase them, but also does not prevent them from chasing, they could be considered by a jury doing something reasonable, which is legal. And then him running is actually committing the offense. So in their mind, you've got the offender who is actively committing the thing, not trying to back away and say, hey, I don't want any part of this. And so in their mind, they're not provoking. It's already been started. He started it in their mind, and it's a mistaken belief. 100%. They were wrong. 100%. Andy admitted on the stand, and they were. I'll say that all day long. But it gets tricky. Anyway, you slice it. This is over bottled water. I see what you're saying, Tiffany C. And to back that up, the defense table having all their bottled water be cans of water instead of something that looks a lot like what Cyrus was picking up out of that convenience store that day and put back. Clearly, they understand that, in many eyes, that's exactly what it's about. I'm under the mistaken belief that chocolate doesn't make you fat. Hey, I'm with you, litigator. Let's unite, convince the rest of the world. Although we'll need someone else to be spokesman. I'm not eligible for weight reasons. Let's see. If Chow didn't have his firearm, he might have not even attempted to chase him down. Sinister Soldier, I hear that, but Andy was in the lead. Andy ran first, Chow was following, and Andy didn't have a firearm. I wonder if that guy they left at the counter just took whatever he was going to buy. It looked like he had a lottery ticket he was trying to turn in. It looked like he had a little scratcher that maybe had some winnings on it. He was trying to cash in. But I also thought that. I'm like, well, you've left customers in the store. I wonder if they're going to be like, hey, everything's on sale. I didn't see anything in the cameras, though. Was he running because he was scared of them or because he didn't want to be caught with an illegal weapon? That could have been why he didn't want them to check his pockets if he had an illegal firearm, but they didn't know he had an illegal firearm.
The principal issue would be whether or not any lesser included to the murder are charged.
Judge, we're not asking for any lesser included things.
No lesser included.
We discussed that with Mr. Chow, and he's in agreement.
You got to say Mr. Chow.
They're doing all or nothing, no lesser included.
Do you have any position on that?
No, Your Honor.
Okay. All right, so other stuff I have in here, of course, standard stuff at the front, duties of jury and judge, charge, arrest, indictment, not evidence, presumption of innocence, reasonable doubt, definition, credibility of witnesses, charge, prior inconsistent statement, charge, definition of intent, charge, direct and circumstantial evidence, definitions, expert witnesses, they have been to testify, charge, and of course, murder. After murder, I have defense of others. I'm assuming what y'all want to charge.
Yeah, John, Mr. Wilson is going to talk to you about
the charge that was in the standard book, our standard charges that have been handed down over the years, I did not find to be adequate. So I have significantly altered it because it didn't, number one, for whatever reason, maybe it's so old and doesn't get utilized, it didn't incorporate that the state has the burden of disproving self-defense. So I put that in for my new self-defense charge, modified a few things. And of course, I wouldn't send it to you, but I incorporated that.
I assume in the entirety of that charge, you'll make adjustments for defense and others and self-defense so that we don't get them.
We can send it to you.
I was about to ask if you could just send us.
Why don't we send you that section and we need to call through some stuff on that, we can do that.
But also, my curiosity always eats me up on your choice of reasonable doubt. So could you send it? Is it
we'll send it
hesitation to act, or is it?
It has both in there.
All right, thank you.
This is the standard one. I know it would be the same thing we used 3 years ago.
Yes.
Jack was used several times since.
No, we know what your charge is.
After that. And there may be some stuff y'all want to add to the defense of others.
Well, I think we do. Ms. Wilson looked through some charges that have been given in other cases. You want to do anything?
Basically, the way I did, I described defense of others as it was in the other one, and then I went through each individual element of self-defense like I typically do in self-defense cases. Added in at the end, after duty to retreat, added in the, which is normally in a self-defense charge, the relative size, age, weight to the parties may be considered in deciding the parent or actual need for force in defense of others and the amount of force needed. Then the next part of that is the exact calculation as to the degree of force which may be needed, all that stuff. I don't know if y'all want into anything else. Now, this charge, voluntary is out. After that, there's the approximate cause charge, which is my standard one, and that's it.
That's pretty
Y'all
simple.
have any?
Judge, we also act on appearances, Your Honor.
Yep, it's in there.
And also,
It is in the reasonable belief, I believe, portion.
Does yours include the mistake?
Yep. I believe it's in there.
So we have mistaken belief coming in.
Y'all should have it by email now.
Very good.
also increased risk of harm in the duty to retreat?
They're just describing these by the headings.
No duty to retreat if it increases your risk. That's what you're talking, Ms. Wilson's talking.
Yeah, defendant had no duty to retreat if by doing so the danger to the person defended of being killed or suffering serious bodily injury will increase.
Okay, and we would ask for a sympathy charge. What charge?
Sympathy.
A verdict in this case cannot be based upon sympathy, passion, prejudice, or...
It's in there, it's in everyone.
Thank you.
It's in at the end. Anything special the state won't?
I found what you were talking about earlier, that person being defended had the right of self-defense, or for them to have the right of self-defense. It must be shown that the person being defended and the defendant were both without fault in bringing on.
I have that in there.
Okay, and I'm sorry, I don't have my email with me, but the only other one that comes to mind, this is from Bixby, and I don't think it's typically a problem, but I don't know if your charge includes it. It stands for the proposition, the burden of the state is carried by disproving any one of the four elements beyond a reasonable doubt. That's outside of Bixby, which is 388 SC 528. That's that capital case out of Abbeville. I think this is a total opinion, but we all know that to be the law. Sometimes it's argued differently, but that says that is a proper jury charge. Actually, it says a jury charge on the issue should state the state has the burden of disproving self-defense, and this burden is carried by disproving any one of the four elements by proof beyond reasonable doubt.
Any objection to that?
Judge, I want to read that case again. I do have some trouble about it, isolating that they have to only disprove one of the elements of self-defense. But I'd like to read that case again.
That's definitely the law.
Yeah, I just, it's a way to word it. And I'd just like to read the case again if it's all right.
Okay.
I didn't, and Jack, you were involved with that case, weren't you? I've got the...
It was my case? That's why I want to read it again.
The Bixby thing that the state just brought up is huge for the prosecution, saying there's case law in Bixby, and they gave the citation that the state only has to disprove one of the four elements of self-defense, not all of them. And so, I mean, I think the defense obviously doesn't like that. They'd like it to say that it has to disprove all the elements, but the judge says that's not the law. The law is that they have to disprove one. So we need to look at the elements of self-defense, first of all, to understand what they are under the law. And then second of all, we need to look at what the state's done to disprove one of those elements. Yeah, I'm north of this. I'm from the northern part of Carolina. Northern Carolina. North Carolina. Do you think they went with no lessers because even manslaughter would life for him depend on his age? No, I think they probably got a read on the jurors, and they think they have some jurors on their side. If you've got jurors on your side who are firmly on your side, making it an all or nothing case would make them have to fully surrender their position to reach a verdict. So I think it was strategic to say, no, we don't want lesser included. Lessers can often be seen as a compromise verdict where the jury can say, like, look, we don't agree. You know, jurors 1 through 5 think it's not guilty, and jurors, you know, the rest of them think it's guilty. 6 through 12 think it's guilty. We're going to settle on a lesser charge where it can be like, well, we're all just okay with this one. I don't like lesser includeds. But this is a good trial. It's had some very interesting moments. I wish the audio were a little better. Yeah, the woman right to the left of the judge is actually the judge's lawyer, her paralegal. It's paralegal. And the one next to the flag is
a couple more things from the defense, Your Honor. Yeah, go ahead. All right, Your Honor, 2 things. Under Nichols, there is, State versus Nichols, there's some language about the ability of the person confronted with harm to act. Maybe in your appearances charge, but since we haven't had a chance to read it, we don't know. So I would beg your indulgence to give us, not right now, but we will get an email off to Rebecca tomorrow.
What's the language you're looking for?
Well, it is language that the defendant does not have to wait for the victim to fire or aim, or even aim before acting in self-defense or defense of others in this kind of situation. So we think that's the law. It sometimes appears.
I have the sentence: the defendant does not have to wait until the victim inflicts harm on the person defended. The defendant has the right to act under the law of self-defense,
and that's in your appearances charge. All right, yes. Your Honor, that would satisfy that.
The victim from inflicting harm on the person defended.
Thank you. The second and last, I think, is we are considering a request for an instruction under 16-13-140. And it's in the criminal code. It relates to what's called the shoplifter defense. Shopkeeper defense.
Here it is.
I'm looking at that. Isn't that more of a civil defense?
Yes.
Like you're sued for detaining somebody?
It covers criminal as well.
It says in a proceeding, and it affords an immunity in a civil case where one is sued for acting unreasonably. But we think it is applicable, perhaps.
It's a stretch. I don't think the judge will include this. He consults his lawyer.
Action.
It says in an action brought by reason of having been delayed by a merchant or merchant's employees or agent on or near the premises of mercantile establishment for the purpose of investigation concerning ownership of the merchandise shall be exempt if the person is delayed in a reasonable manner for equal time. Reasonable cause exists to believe the person delayed had committed the crime of shoplifting. It says in an action, which I think when I read it the first time off the cuff, I thought it meant a civil action.
Your Honor, in the infinite wisdom of our legislature, they didn't clarify that. So I'm not certain, and I was not able yet to find a case that tells me that is solely relegated to the civil side. We would like an your permission to consider it a little bit further, do a little more research, submit charge, proposed charge over the weekend, hopefully tomorrow, and we can take it up very briefly on Monday. But it does relate, Your Honor, in a fashion to the circumstances here. And that is, even if only a civil matter, is a recognition that a shopkeeper confronted with a set of facts would be reasonably able to detain, and implicit in that is a reasonable pursuit of a person under the circumstances. And so, of course, the arguments in this case will turn on the reasonableness of this pursuit, which the state will call a chase, which we have called, and Mr. Chow called, following. So we think
they also call it chase.
Ask your permission to submit something to you, and we'll deal with it expeditiously on Monday morning.
Okay.
Monday morning, yeah.
What's the state's position on that?
Completely object to that. It's completely inapplicable to the fact patterns of this case, and I don't think it's a criminal offense.
Well, I'm not sure I do either, but I'm certainly not going to preclude the defense from at least looking into it and submitting something. It does mention, detained or delayed on the premises. And,
actually on his near, I think, but the legislature again didn't define near.
Just as so we can all remember what's fresh in our mind, there has been absolutely no testimony about any intent to detain anybody. The very best it was to follow and to find out the direction
where he was going.
Yeah,
it's a good argument by the state there.
All right, well, y'all can, and I don't even think there were any cases out there citing that. Were they? Yeah. I did. I remember it came up last week somehow.
It's
Maybe you had it in a motion or
pretty
something.
fallow ground, I must say, but I'd like a little further opportunity to look into it. We'll get you something tomorrow.
Okay.
Thanks.
I'm not going to look at it.
Well, then I won't rush. I'll make it to you no later than, it won't be Monday morning.
Yeah, Sunday evening will be fine.
Thank you.
Most all the reported cases, I think, are all civil cases. All right, anything else?
Maybe. I mean, there's still an argument to be made there.
We will be looking over the material.
There's one thing about the right not to testify, they can't consider it. There's a line in there I always object to about the constitutional right not to testify. It always sounds like a mob thing. I think Gail knows.
I never understood that.
It's just got one line about asserting a constitutional right. It sounds like something they would say in front of a Senate committee investigating a mob. I think you took it out in a Harmon case.
Yeah.
I don't have the objection to that.
The sentence of defendant has the constitutional right to remain silent, and the assertion of this right must not be considered by you in your deliberation.
Let me get this out here before I forget it.
Right to remain silent. That's what
It's regarding the shopkeepers' protection.
I don't even know what the right to
What all do you want?
The right to remain silent is the part that I have a problem with, because the rest of the charge, I think, makes it very clear they're not allowed to discuss that. It will bring it up in the jury room. There's something I've objected to, probably.
He doesn't like the right to remain silent, at least the way the charge is written.
Should I say then the defendant's failure to testify?
Not failure.
Cannot be considered or discussed.
Must not be considered.
Or discussed, he wants.
By you in your deliberation. Read out constitutional right to remain silent and the assertion of this right.
constitutional right to remain silent for Department Addicts.
That's the strongest.
Because it sounds to me like they're invoking the Fifth Amendment, which I don't like.
Because of
You want that whole sentence out?
Pardon?
You want that whole sentence taken out?
Right to remain, constitutional right to remain silent.
Well, the whole sentence is the defendant has the constitutional right to remain silent, and the assertion of this right must not be considered by you in your deliberation.
Well, if you pick up and just say that the fact that the defendant does not testify, the rest of your charge on that cannot be considered in any
Two
way.
sentences before that, that defendant does not testify is not intended to be considered by you in any way in your deliberation and your consideration of the question of guilt or innocence of the defendant. It must not be considered by you in any manner whatsoever.
That's acceptable right there.
All right, so we'll take that. We'll take the whole sentence out. Is taking any wrong with that?
No, Your Honor.
Okay. It said, it said in there like 3 times.
Yes, to be on behalf of Lucky Luciano, we would appreciate it.
Is that a purple power strip? Is there a purple power strip?
Just being clear, I mean, Jack said he didn't like the Fifth Amendment.
Squirrely is on record.
Just to be,
I like it if I have to invoke it.
just to be clear, Jack says he doesn't like the Fifth Amendment. He
Has
said.
the right to remain silent, it's not the ability.
I'm going to be silent by my age.
All right, well, if that's all we have, we will see y'all Monday morning.
I sent another version that we didn't do it in the everything else.
All right, we're gonna fade this out. Let me say this. There's one little bit that the judge shared there. They were talking about the shopkeeper's law. That right at the very end, the defense asked to include the instruction about the shopkeeper's law, about the right they have to detain and the protections they have. And the judge is like, I don't know about that one. I thought that was just for civil. That's a civil protection. But an argument could be made that no, it's a criminal and a civil protection. The reason all the case law is civil only is because a case would be dismissed. Criminal case would be dismissed because of this law. I think that would be a stronger viewpoint for the defense to say, you're not going to have these cases because if these facts exist, the shopkeeper's law dismisses the case, much like it would, finding that it was self-defense would dismiss the case. I'm not sure what they're going to argue on Monday, briefly, but it looks like they're pretty much on the same page. The discussions were not quite as heated as I thought they might be, but it is important that we're going to hear a little bit specifically about the self-defense, the right to self-defense, as people are getting ready to leave. It looks like a little prayer group or a little huddle. Their group hug, that's with Mrs. Chow. There in the courtroom. But the judge says, when I was putting in the self-defense jury instruction, I found the pattern self-defense instruction lacking. And so I added some terminology to it. Specifically, he says, I added that information that the jury needs to know that the prosecution has the burden to prove that it was not self-defense. So he's added some terminology. I can't wait to hear what exactly he added, what the wording is there. That'll be interesting. What about Cyrus's right to self-defense? I think he was also in the right. 100% Northwest. He was in the wrong. You could be charged as a under 18 possession of a firearm, felony. I think he could get that. But he also, in South Carolina law, they treat this separately. He also had the right to use self-defense.
Call from
AWOL.
AWOL, what's happening, my friend?
What's up, Scott and chat family? Love you all. Hope everybody is good.
Yeah, we are. We're really good. It's Friday. It's time to go home. It's 4:20. I'm not saying that's anything, but it's 4:20 on a Friday.
Family-friendly channel, buddy.
I'm just noting the time. That's all I'm doing.
Yeah, fact.
Yes. What's on your mind?
Okay. Everybody knows I'm pro-defendant. Based off the burden of the state, right? That's just how I feel. I'm okay with once the evidence comes out that I can say, yeah, he's guilty. It's not. I'm not delusional when it comes to
you're not
just
always the defendant is always right. No one's ever guilty.
Well, oh no. I'm saying that from the correct. From the beginning of a trial, I go by the Constitution, and I want the state to meet their burden. If the state meets their burden, I go guilty. Sure. Do I hold that burden to a level maybe a little too high? That's like, I can see how someone could disagree with me, but like, okay, your position on their burden is so extreme that nobody would get found guilty if everybody thought like me. I understand that I could be a little extreme with that. But here, I started off morally guilty. Legally, not guilty. Mm-hmm. I watched the evidence, and then I went, oh, he's morally not guilty. Right? I started morally guilty.
Okay.
But then went morally like, oh, he's guilty. And then I had to talk to myself and go, hey, you got to look at this as the law.
Right.
Right? So I watched all of this, and I called my friend during lunch who disagrees with me on purpose.
You phoned a friend.
I phoned a friend who I debate, and I had on my podcast. Mm-hmm. Some weren't able to be aired. It got that contentious, right?
Oh, wow.
And he disagrees. I mean, he's my best friend, but he disagrees with me just to do it, just to like make fun of me, because he gets a kick out of it. Because I'm so passionate.
Yeah, he always takes.
But it's fun for him.
Yeah,
right, and it's fun for him. But after that conversation, I gave him minor details. He didn't know this case, but he knows the law-ish. And I'm hearing you talk about it's not illegal to chase. Because this is the thing, I keep going back to how I feel morally about this. But I can't do that here. We have to go by the law. If I always claim that, well, then I have to still have that here. Mm-hmm. If that's my position all the time. So if you're saying that legally they can chase. Also, vigilante justice, they didn't put hands on them.
I want to word this carefully. It's not legally they can chase. It's that legally they weren't prevented from chasing him.
Okay, yes, my bad. Yes,
so
correct.
They weren't operating under a protection of a law. They were just not violating any. It was still I think it was a terrible idea. It was really stupid. It's advised against in pretty much every situation. Even cops are very careful when they take chase, and they have very strict protocols when they chase. So,
and this is the issue I've seen. I don't, not a crazy tangent, but I've seen some people debate, if this was a cop issue, right? This is Pickles still. Yeah. I'm talking about the law here. They have a different set of standards when they're in uniform performing their duty that does not apply to citizens. So when someone can see a cop situation happen, it goes what a reasonable officer would do, not a civilian. So the law explains that differently. You know what I mean? So I see some people trying to compare that, and I go, well, this is different. You can't, that's apples and oranges. I'm sorry, respectfully, I disagree. Apples and oranges here. Again, based on what you said, not illegal, like they were allowed to, but they didn't break any law. There's like nothing on the books here. Maybe this will, depending on the outcome, set a certain precedent.
I hope not, because it's just going to cause more problems down the road. We try to make all these rules to fit every situation, and we turn up, just causing problems, unintended consequences all over the place. I think the problem is we have a terrible situation where a lack of communication and misunderstanding, and whether it was intentional or not, we don't know. We will never know. But it led to an escalation that resulted in a terrible, terrible tragedy, where someone who had not done anything wrong to them, okay, and I believe that, take the firearm and his hoodie out of the question. It's not an issue. They didn't know about it when it went to the store. It's not an issue in this case for this part. He had not done anything to the Chows, and he ends up dead. I think he 100% had the right to defend himself if he was in fear for his life, which I think he was based on the fact that he ran out of his shoes trying to get away.
That's what I debated too. But yes, please. Please elaborate. Yeah.
He's in the right. At the same time, the Chows aren't in the wrong. They're operating under a mistaken belief. They're trying to detain. The legislature in South Carolina has gone as far as to make shopkeeper laws literally to protect shopkeepers who are trying to stop people from stealing from their stores. They've codified that. They see that's enough of a problem. There has to be protection. So that there's some support for what they're doing. They may have taken it too far, and the jury's going to decide if that's reasonable or not. But arguably, both of them were looking at this thinking they were in the right. Right?
Exactly.
So, but here we are saying because somebody died, there has to be a bad guy, and there might not be one.
I said that yesterday. I don't know how to say this because some people think that the position that I take is cold or the blood in my veins is cold. That's not what I'm trying to say. I want everybody to live a happy life. I'm just saying we have to see this as we're trial watchers, right? Yeah. So we are here for the law. We're not here to watch Selling Sunset on Netflix or did you see what the Kardashians did? I'm not judging either way. I'm just saying we're here for the law as trial watchers, but it can somehow, if you watch it long enough, it can get convoluted where it becomes a reality show as a trial watcher because this is your novel. This is not a novel. These are people's lives, and then there's law. So we have to be careful how we feel about things because if the shoe was on the other foot and this was your family member, I would like to imagine, or maybe, again, I'm assuming, you know what that means, that you may have a different position if your mother owned a flower shop and this happened and your brother was there and he chased. So you get what I mean?
Without twisting it into a completely different scenario with family, I would say that my rationale as I'm viewing this right now, if it had been the opposite, if Cyrus had shot Andy and Andy died, I think Cyrus would be protected. That this would be considered self-defense.
I agree.
It's still wrong for him to have the gun. You can charge him for that. That's great. But I think he had the right in that situation to self-defense. So him being in the right with these two people chasing him because Cyrus knew he didn't take anything.
Right.
Okay? Cyrus is like, I didn't buy anything, and they're chasing me down. These two guys yelling at me, chasing. Maybe he didn't understand him. I don't know what he heard. There's all sorts of noise with cars on that street. You saw the body cam. You know, what he perceived and everything else, he could have been terrified for his life and literally frantically trying to get his illegal possessed firearm to save himself. And he would have the right to do that. And if he managed to pull that off, I would be championing his cause right now.
100%.
Unfortunately, it went the other way. And I think that, they also have that same... They were in the right in their mind and possibly even legally. Not just because of the mistaken, protection for mistaken belief, but
I think my issue here is I'm trying again, morally, all of this was uncalled for. This is all unnecessary morally, but I have to disengage from that thought and look at the law as if what the law is. Like it should be looked at. Lady of Justice is blindfolded for a reason, right? So, if I look at this on the timeline, I have a hang up that even I said, pro defense side, that he was going after his son for defense of others and what would happen if my son, but then I have to still legally look at it and go, yeah, but it's not like his son left the store and then the dad ran out and said, where's my son?
Yeah,
I felt like they were in cahoots.
There was not time to process that thought. I'm worried about my son. I better follow. There was not time. It was move, son, get out of the way. He was hauling. They were headed out there to stop.
So I feel like they were working in conjunction with each other. So this is why I'm like, I don't know if the defense of others counts here because You ran with your son. It's not like your son left and you like, where is he? Let me go save him.
Okay.
No, you and your son
Let me
chased
present this
child.
Let's say Cyrus didn't have a gun, and they catch him. And they're like, "Hey, give us the water," right?
Mm-hmm.
And he says, "I don't have any water. I didn't take any." And they drag him back to the store. Get back here. We're calling the cops. We're watching the footage, and they watch the footage. I believe the Shopkeeper Act would protect them. Had they caught Cyrus and dragged him back and said, "You're staying right here. You're not going anywhere, son. We know you stole. I don't care. You might have thrown it. We didn't see where it went, but we've got on video you stole." And they don't. It's not on video. He didn't steal. I believe the Shopkeeper Act would protect them criminally and civilly in that situation.
Right. Yes. Yeah. Okay. Yeah. I agree there.
So we can boil it down to just what happened when the gun was produced by Cyrus. That's all this case comes down to.
That's the point of contention that I had with my friend that I debate with all the time. I was like, okay, he said, again, he's only hearing what I'm telling him. So he doesn't have all the facts. So I can't really take his opinion that good because he's only basing his opinion off of what I'm saying to him. But he's like, what happened in the store? Did he steal? I was like, he didn't steal. I was like, he's like, but did they know he didn't steal the water? I'm like, I don't think they knew that he did or didn't. I think they thought he did. Right? Mm-hmm. My only issue is what happened when the Blammy situation happened. And that is what I feel like this case should be settled on. Sure. Did what allegedly they saw in the store play a role? 100%. But it doesn't matter whether he did or didn't. It matters that at that moment, who thought what? If I was Cyrus, I would have been like, oh my God, they're chasing me. Even though I'm 14 and I got a Blammy, I might turn around and go, who the heck are you people? So he had the right to defend himself at that point. Yeah. Right? This is why this is so crazy.
I agree. And I don't think we can boil it down to the value of the item. I don't think you can say, well, there's a threshold, you know? I'm saying if it was $1 million or 1 penny, the store has a right to defend their property because everybody goes, it's only water. I'm sorry, it doesn't matter to me. Theft is theft. I'm sorry. You don't have the right to take what's mine. I might personally have a level where I say, hey, somebody just took my $1, and I'm like, they probably need it more than me. But if they break into my safe and steal my life savings, I'm not going to be like,
we're going to have a problem.
They probably need it more than me. I think I have the right to do that, but I don't have the right to tell them what their level is, whether it's a penny or a billion pennies. Let me read this really quickly because South Carolina, this is the shopkeeper law. In any action brought by reason of having been delayed by a merchant or merchant's employee or agent on or near the premises of a mercantile establishment for the purpose of investigation concerning ownership of any merchandise. So basically, in any civil, it says action. It doesn't say civil or criminal because there can be criminal actions and civil actions. It shall be a defense to such action if, 1, the person was delayed in a reasonable manner and for a reasonable time to permit such investigation, so they can stop you, even if you didn't steal anything, and be protected. And 2, reasonable cause existed to believe that the person delayed had committed the crime of shoplifting. So that protection is pretty strong, I think, on this one. Let me say, when it comes to the state, I think there are 2 things they're going to have a hard time with. The big challenges they have to overcome. One, obviously, is proving that it was not self-defense. You have to prove that, basically, that he didn't point the gun at Andy.
Right.
Or one of the 4 elements. We're going to have to look at what those are probably on Monday. And the other thing is something important has escaped me. I should have written these down.
That they were allowed to chase him, right? And not, you know what I mean. Semantics. it's like we're not going to argue over semantics because this is a phone call, but more or less, not legal, not illegal. It's a gray area. Like, yeah. And then citizen's arrest comes into play. This can get a little squirrely where maybe this case sets precedent over something.
Yeah, it's Alex the Dane mom asks, okay, but does the law say you can chase them even when they leave the property? The law uses the word near. What is
now,
near?
what's near? If we want to talk legal language, is near 100 yards or 1,000 yards?
Yeah. So and that's
where is in the legal definition of near?
That's
in
probably going to be decided in case law,
near?
Where they say, look, you saw somebody shoplift and hop in a car and drove, and you caught up to him on I-85 or whatever, exit 700.
3 states over. Is that still near?
It's like, that was 2 tanks of gas later. That's not near. But obviously, there's also a point where he's like, yeah, but I was already 2 steps away from the store. They shouldn't have been able to stop me because I wasn't near the store anymore. And that's why the Supreme Court takes up appeals to hear cases like this to define and set that out.
I just think this whole, again,
reasonable.
This is why I love. I'm sorry.
I'm sorry. I'm reading some comments here. Jody says reasonable is not a football field. 15 seconds. If you can make it out of the store with your item and run for 15 seconds, is that where it's free? You can't chase after that.
And I would also like to say there's a comedian. I'm not going to say his name because I don't know, copyright, whatever. But he said, I was watching a football game. I left my couch, went to the refrigerator, got a can of soda, and went back to my couch. Within that amount of time, this human ran 100 yards, scored a touchdown with 12 people chasing him. Think about that. I left my couch, went, got a soda, came back. He said I had to dodge an ottoman. That was the only thing. And I missed the play. He did that in real life, in real time, in 100 yards. So time and space and athleticism, I think that gets a little, again, isn't that like what ifs and what aboutisms and Monday morning quarterback and, oh, yeah, but what if this, but if this. The law doesn't work with what ifs and what aboutisms, in my opinion.
Yeah. I'll say this.
So I just think this is difficult. I think this is this is like a moral problem. Then there's
because the outcome was wrong. The outcome was bad.
Because he died. Oh, I almost said a bad word. Because he passed.
I feel the same way about Tatiana Jefferson case with Aaron Dean. He was the officer who responded to see, there was a call that came in from a neighbor. Oh, we've got a house that's open. He's like, he's afraid there's a burglar in there. He's trying to protect
That was the one
homeowner.
Where they walked in through the side gate.
Shoots through the window. Yeah.
Right. And they were trying to claim, well, you passed the curtilage of her home when you opened her gate. So, like, she almost had the right to aim her blammy.
Oh, she did.
Out the window.
I support her 100%. She was in the right to defend herself. She saw
I
somebody
feel like
outside
she
with
was.
the gun. Yes.
I feel like she was.
But I also thought that Aaron Dean was in the right. And that was something that should be, it's tragic. It's terrible. It shouldn't happen like that. It should be decided civilly or, sorted out civilly.
Yes.
But civilly doesn't bring people back from the dead. It doesn't. We haven't got
this is why
court that can do that.
I'm sorry. And this is why I feel like we have to watch, again, not, you know what, let me say it. I don't want to project. I feel like this is why I watch trials, because it has made me smarter when it comes to debating people or seeing situations, because it makes me steel man their position, which is the opposite position of mine. And then I go, do I even believe what I'm saying? If I steel man my opponent, and within that process, my opponent makes sense, then I don't know if I believe my own position then, which is difficult to do. You got to put your ego aside. You got to be a little bit humble. But if my opponent's position makes a little bit of sense to me, I have to sit down, reevaluate, what do I really feel? So these cases go, okay, again, we're not going to go on a tangent on what happened, but okay, none of this is good. No trial is like, oh my God, we're gonna have a trial. So who wins a Lamborghini?
Yeah.
It doesn't, like, all trials are negative.
Let me say, we're looking at this. I'm looking at this from a legal standpoint, and I hate it. Honestly, I hate that we're sitting here saying who's right and who's wrong when it's wrong that we have a 14-year-old who's dead. Period. That it's wrong. He paid a price. We can't undo that. But the way the law is written, I believe the Chows might be right. I don't think morally the Chows were right. I like to think that I would do something incredibly different in that situation. That I would be
I agree.
That Cyrus would be my friend if he gave me the store. It's before I assumed he was my enemy.
I thought I would have been like, yo, why are you moving so funny? Let me talk to you. What is your problem? Are you okay? Instead of being accusatory or following, I'm like, yo, are you good? What's the matter? Like, because if I was already suspicious, I want to find out why. I feel that way, not him. Why do I consider him suspicious? Yeah. So I would have to internalize that and go, is he or is this my problem? Yeah. So then I go, well, okay, let me figure it out. Hey, young man, you good? What's the matter? Hopefully he talks to me. He may not, but at least I did my part. So I think you're right.
Yeah.
But anyway, I've talked to your ear off long enough. I try to make my call.
We haven't talked in a while, so I gave you some extra time.
I apologize.
Thank you, my friend. Good talking to you.
Well, all right. Love you. Love Chat family.
Love you, man. Bye.
Bye.
I honestly, I think that I look at this case and I think we can do better, right? That it shouldn't be this. It shouldn't be that, we study the law so we know how far we can push it to make sure we're right. I think the law should be in place for extreme situations that are just that, rare and extreme. Not that we push up to the limit to do all we're legally allowed to do because we're looking out for number one. That's why I have a closing that we do. I say this every day, but I mean it. I think that if we incorporate just a little bit of kindness in our interactions, not just with the people we know and love, but the people we don't know yet, it can make a difference, and it can save situations like this from ever happening, from ever developing to this point. We're going to take the weekend off. We'll be back again Monday with the final on this, and we'll go to verdict to watch after closing arguments. But tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. Now please stay safe till we go live again on Monday. We'll see you all. You guys have a fantastic weekend. Be good to each other. Hopefully I didn't offend anybody. Some days I don't take a stance on this, and I did on this case, and I realize it's a hot button issue. I may be wrong, and the jury may prove me wrong on Monday, and I'm okay with that. But you guys are all amazing. Thank you very much. Have a wonderful, wonderful weekend. Watch the podcast if you didn't get it last night, because we talk about pizza a lot. And there's a whole thing about caviar that apparently is going to come again on like 3 podcasts from now, where I'm going to be eating caviar for the first time in my life, and probably for the last as well. So that's all good. You guys are amazing. Have a wonderful night. Thank you all. I appreciate it. Mods, you're incredible. Thanks for doing the hard work on this one. You're amazing. You guys be good to each other. Bye-bye.
Thank you, sir. You're my new best friend.
Don't miss the forest for the